Florida has a landlord-friendly tenant screening environment with minimal state-level regulation beyond the federal baseline. The governing framework includes the Florida Residential Landlord and Tenant Act, found in Florida Statutes Chapter 83, Part 2, along with FCRA and the Florida Fair Housing Act. Florida gives landlords broad discretion in the screening process, and the state's strong preemption provisions and conservative regulatory approach ensure statewide uniformity. Let's start with application fees. Florida has a specific statutory provision that addresses application fees, but it doesn't cap the amount. Under Section 8349, Florida law addresses security deposits and advance rents, but doesn't impose a dollar limit on screening fees. Landlords can charge whatever they determine is reasonable for the cost of screening. However, Florida law does address application deposits, money collected to hold a unit while the application is processed. If the landlord collects an application deposit, the terms of whether and when it's refundable must be clearly stated in writing. The distinction between a non-refundable screening fee and a potentially refundable application deposit matters in Florida. Best practice is to clearly label each charge, specify what is a non-refundable screening fee for the cost of running reports and what, if anything, is a deposit to hold the unit, and get the applicant's written acknowledgement. Most Florida landlords charge between $25 and $75 per applicant. In highly competitive markets like Miami, Orlando, and Tampa, some landlords charge toward the higher end, reflecting both the cost of screening and the high volume of applications in strong markets. Keeping fees proportionate to actual costs is always good practice. Criminal history screening in Florida is unrestricted at the state level. Florida does not have a ban-the-box or fair chance housing law for housing. There are no state-level restrictions preventing landlords from asking about criminal history on the initial application. Landlords can inquire about arrests and convictions, can use criminal history as a screening factor without conducting a formal individualized assessment, and are not subject to state-mandated look-back period limits. Florida has a preemption statute, Section 166, DOS 043, that limits the ability of local governments to regulate the landlord-tenant relationship. This preemption has been broadly interpreted and effectively prevents Florida municipalities from enacting local screening restrictions. As a result, no Florida municipality has enacted local criminal history screening restrictions for housing. Miami, Orlando, Tampa, Jacksonville, Fort Lauderdale, and every other Florida community operate under the same unrestricted framework. This preemption is significant because several Florida cities, particularly Miami-Dade County, Orlando, and Tampa, have politically progressive environments where additional tenant protections would likely have been enacted without preemption. The preemption ensures statewide uniformity. Florida has provisions for record sealing and expungement under Florida statutes sections 943.0585 and 943.059. Florida distinguishes between sealing, which restricts public access but doesn't eliminate the record, and expungement, which physically destroys the record. Once a record is sealed or expunged, it should not appear on a standard criminal background check. Landlords cannot consider sealed or expunged records in screening decisions. Florida's sealing and expungement process is more restrictive than many states. Eligibility is limited, and individuals can generally only seal or expunge one arrest record in their lifetime. This means that many Florida residents who have criminal histories may not have been able to clear their records. Landlords should be aware that a significant portion of the applicant pool may have criminal records that remain accessible. Florida has not legalized recreational marijuana. Possession remains a criminal offense, though medical marijuana is legal under the state's constitutional amendment. Landlords can consider marijuana possession records in screening, but should be thoughtful about the weight given to minor possession charges given the national trend toward legalization and Florida's own medical marijuana program. HUD's 2016 guidance on criminal history and disparate impact applies in Florida. The state has one of the most diverse populations in the country, with significant African American, Hispanic, Caribbean, and immigrant communities across the state. Criminal history policies that disproportionately affect these populations face scrutiny under federal fair housing law. Florida's demographics make disparate impact a particularly relevant consideration. Blanket rejection policies create significant risk in a state where the applicant pool is extraordinarily diverse. Documenting your criteria and applying them consistently is essential. Source of income protection does not exist at the state level in Florida. Landlords are not prohibited from considering the source of an applicant's income when making screening decisions. Landlords can legally decline applicants who pay with housing choice vouchers, Social Security, disability payments, or other government assistance. Florida's preemption statute would likely prevent local municipalities from enacting their own source of income protections. No Florida municipality has enacted a local source of income protection ordinance. Participation in voucher programs is entirely voluntary. For credit reports, Florida follows standard FCRA requirements: permissible purpose, written consent, and adverse action notice procedures. Florida does not impose additional state-level requirements for credit report access, adverse action content, or notification timelines beyond FCRA. Florida's fair housing protections under the Florida Fair Housing Act, found in Florida Statutes Chapter 760, Part 2, prohibit discrimination in housing based on race, color, religion, national origin, sex, disability, and familial status, mirroring the Federal Fair Housing Act. Florida has not added additional protected categories such as sexual orientation, gender identity, marital status, age, ancestry, or source of income at the state level. The Florida Commission on Human Relations investigates fair housing complaints and has enforcement authority. While the state law mirrors federal protections, several Florida counties and cities have enacted local non-discrimination ordinances with broader protections. Miami-Dade County, Broward County, Palm Beach County, Orlando, Tampa, St. Petersburg, Key West, and numerous other jurisdictions have local human rights ordinances that include protections based on sexual orientation and gender identity. Landlords in these jurisdictions must comply with the broader local protections, even though state law doesn't explicitly protect these categories. The interaction between Florida's preemption of landlord-tenant regulation and local civil rights ordinances follows a similar pattern to Georgia. Cities can enact civil rights protections covering additional categories, even though they can't regulate the financial terms of the landlord-tenant relationship. This means that sexual orientation and gender identity protections in Miami-Dade, Broward, and Palm Beach counties coexist with the state's preemption of landlord-tenant regulation. From a practical standpoint, Florida has one of the largest and most active rental markets in the entire country. The third most populous state with a massive and growing renter population driven by population growth, tourism, military presence, and international migration. South Florida, Miami-Dade County, Broward County, and Palm Beach County represents one of the most complex rental markets in the nation. Miami's economy is driven by international trade and finance. The city is the gateway to Latin America. Tourism, healthcare, real estate development, technology, a growing startup scene in areas like Wynwood and Brickell, and the cruise industry. The applicant pool in South Florida is extraordinarily diverse, including significant Cuban, Haitian, Colombian, Venezuelan, Brazilian, and other Latin American and Caribbean populations, along with European, Middle Eastern, and African communities. Screening in South Florida involves unique considerations. Many applicants may have international credit histories rather than U.S. credit files. Some applicants may be recent immigrants with limited U.S. documentation. Income may come from international sources, self-employment, or family businesses. Having clear criteria for evaluating applicants with non-traditional credit and income backgrounds is essential for South Florida landlords. Standard mainland screening templates may not work well in a market where a significant portion of the applicant pool has international backgrounds. Fort Lauderdale, Hollywood, and the Broward County market have strong demand driven by proximity to both Miami and Palm Beach. Boca Raton, Delray Beach, and Palm Beach County have an affluent market supplemented by seasonal residents. The Tampa Bay area, including Tampa, St. Petersburg, and Clearwater, has one of the fastest-growing rental markets in Florida. The economy is driven by healthcare, including Tampa General Hospital and Bay Care, financial services, including USAA's regional campus, technology, tourism, MacDill Air Force Base, and the University of South Florida. Military tenants from MacDill represent a meaningful portion of the Tampa rental market. Tampa's BAH rates are moderate and influence pricing near the base. Orlando has an enormous rental market driven by the tourism and hospitality industry. Walt Disney World, Universal Studios, SeaWorld, and the broader theme park ecosystem employ hundreds of thousands of workers. Healthcare, including Advent Health and Orlando Health Technology, the growing tech corridor along I-4, and the University of Central Florida, one of the largest universities in the country by enrollment, also drive demand. Screening in Orlando requires particular attention to hospitality industry income. A massive portion of the workforce earns hourly wages with variable hours and tip income. Having clear criteria for evaluating hospitality workers' income, including consideration of overtime patterns, seasonal variations, and tip income, ensures fair evaluation of applicants in the industry that drives the local economy. Jacksonville, the largest city by area in the contiguous United States, has a moderate market driven by logistics. The Port of Jacksonville, healthcare, including Mayo Clinic, Florida, financial services, including FIS and Fidelity National Information Services, and Naval Station Mayport and Naval Air Station Jacksonville. Military tenants represent a significant portion of the Jacksonville rental market. BAH rates for Jacksonville are moderate. The Space Coast, including Melbourne, Cocoa Beach, and Titusville, has a market influenced by the Kennedy Space Center, defense contractors, and the growing commercial space industry. The Treasure Coast, including Port St. Lucie and Fort Pierce, has a more affordable market that has attracted residents priced out of South Florida. Southwest Florida, including Fort Myers, Naples, and Cape Coral, has a market shaped by retirement migration, tourism, and the devastating impact of Hurricane Ian in 2022. The hurricane destroyed significant housing stock and displaced thousands, and the rebuilding process has affected the rental market. Screening applicants displaced by hurricanes requires sensitivity. Gaps in rental and credit history attributable to storms are common and beyond the applicant's control. The Panhandle, including Pensacola, Fort Walton Beach, and Panama City, has markets influenced by tourism and significant military presence. Naval Air Station Pensacola, Eglin Air Force Base, Hurlburt Field, and Tyndall Air Force Base generate enormous military rental demand across the Panhandle. Military tenants represent a dominant portion of the rental market in communities like Fort Walton Beach, Niceville, and Navarre. Landlords in the Panhandle should have streamlined military income verification processes. BAH rates vary across the Panhandle's installations. Gainesville, home to the University of Florida, Tallahassee, home to Florida State University and Florida A&M University, and other college towns have student-influenced markets with seasonal turnover. Screening students with limited credit and rental history requires consistent cosigner or guarantor policies. Florida's hurricane risk is a constant factor across the state. Major storms can disrupt rental markets, destroy housing stock, and displace tenants. Landlords should maintain adequate insurance, including wind and flood coverage, and have a screening approach that accounts for storm-displaced applicants. One best practice for Florida landlords: clearly distinguish between screening fees and application deposits in your written materials. Florida law treats these differently, and conflating them creates confusion and potential disputes. Label each charge clearly, explain what each covers, specify whether each is refundable, and get the applicant's written acknowledgement before collecting any money. Another best practice, given Florida's extraordinarily diverse population, develop screening criteria that can fairly evaluate applicants from a wide range of backgrounds. In South Florida particularly, applicants may have international credit histories, income from international sources, and rental backgrounds from other countries. Having documented alternative evaluation methods, such as considering international bank statements, accepting international references where verifiable, evaluating employment stability, and using cosigners, ensures you can serve the diverse applicant pool effectively. A third best practice, for landlords in jurisdictions with local non-discrimination ordinances, including Miami-Dade, Broward, Palm Beach, Orlando, Tampa, and others, ensure your screening process complies with the broader local protections covering sexual orientation and gender identity. Review your application form, train staff on local requirements, and ensure that no aspect of the screening process touches on these locally protected characteristics. Florida does not have a statutory cap on security deposits. The deposit amount is governed by the lease terms. The deposit must be returned within 15 days if no deductions are claimed, or within 30 days if the landlord intends to make deductions. The landlord must provide written notice of the intention to claim deductions within 30 days, and the tenant has 15 days to object. The deposit must be held in a separate account, either an interest-bearing account where interest is paid to the tenant, a non-interest-bearing account in a Florida banking institution, or the landlord can post a surety bond. While the flexibility on deposit amounts provides financial protection, thorough screening remains the most effective tool for tenant selection. For the complete guide to Florida tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.